The decision is made long before the courtroom empties and long before a prison door ever closes behind the defendant. Once the conviction is entered, the destination is already sealed. For some terrorism offenders, that destination is not a military brig or overseas detention site, but a civilian supermax facility inside the continental United States. One of the most well-known is the United States Penitentiary Administrative Maximum Facility, better known as ADX Florence, located in the high desert of Colorado. Since the mid-1990s, ADX has carried a reputation as the most secure federal prison in America, designed to hold inmates considered too dangerous for any other setting. Among its population have been individuals convicted of high-profile terrorism offenses in federal civilian courts, raising a question many Americans continue to ask. Why are certain terrorism convicts sent to a Bureau of Prisons facility instead of a military prison under Department of Defense control? The answer begins not with the prison itself, but with the courtroom where the conviction occurs and the legal framework governing that prosecution. When a terrorism suspect is charged in federal civilian court, the case proceeds under United States criminal law, not under the law of armed conflict. That distinction matters because the agency responsible for housing convicted federal criminals is the Federal Bureau of Prisons, not the U.S. military. Once a defendant is convicted in federal court and sentenced to a term of imprisonment, custody transfers to the Bureau of Prisons as a matter of statutory authority. Military detention facilities, by contrast, are designed primarily for service members under the Uniform Code of Military Justice or for wartime detainees held under separate legal authorities. Terrorism cases prosecuted in civilian court fall outside that military jurisdiction, even when the crimes involve acts of political violence or international networks. This division of responsibility is rooted in constitutional structure, federal statutes, and decades of precedent about who holds custodial authority after conviction. If stories like this matter to you, subscribing helps ensure these systems and decisions continue to be examined with clarity and depth. The Bureau of Prisons then conducts a classification process that determines where a newly sentenced inmate will serve time within the federal system. That classification is not based solely on the label of terrorism, but on factors including sentence length, criminal history, escape risk, and institutional security concerns. In certain cases, the analysis concludes that the individual poses an extraordinary management challenge within the prison environment. That conclusion can lead to placement at ADX Florence, a facility specifically built to manage inmates requiring the highest level of security and control. ADX operates under what the Bureau calls administrative maximum conditions, involving single occupancy cells and tightly regulated movement within the institution. The purpose is not to impose additional punishment beyond the sentence, but to maintain safety, order, and security inside the federal system. However, critics and observers often question whether terrorism offenders should instead be confined in military facilities designed for national security detainees. Part of that debate intensified after the attacks of September 11, 2001, when the United States confronted new categories of suspects linked to transnational extremist groups. In the years that followed, policymakers faced decisions about whether to pursue prosecutions in civilian courts or military commissions. When the government chooses a civilian trial and secures a conviction, the sentencing judge imposes a federal prison term like any other criminal case. At that point, the military does not automatically assume custody because the defendant has been adjudicated under civilian criminal jurisdiction. This legal pathway contrasts with detainees captured in overseas combat operations and held under wartime detention authorities. Those individuals may be confined in facilities such as Guantanamo Bay under different legal frameworks that do not involve traditional criminal convictions. But when a terrorism suspect is arrested on U.S. soil, indicted by a federal grand jury, and tried before a civilian judge, the outcome follows domestic criminal procedure. That procedural choice has practical consequences, including the ultimate destination of incarceration. Supporters of civilian prosecution argue that the federal court system has decades of experience handling complex terrorism cases securely and effectively. They point to successful convictions, lengthy sentences, and the ability to manage high-risk inmates within the Bureau of Prisons. Opponents argue that terrorism represents a form of warfare and should be addressed primarily through military channels. Yet the Constitution grants Congress the authority to define federal crimes and establish courts to adjudicate them, including terrorism-related offenses. Congress has enacted statutes criminalizing material support for terrorism, conspiracy, and other related conduct, placing them squarely within federal criminal law. When a defendant violates those statutes, the case belongs to the federal judiciary, and the resulting sentence belongs to the federal prison system. That institutional chain explains why some of the most notorious terrorism convicts ultimately arrive at ADX Florence instead of a military stockade. Inside ADX, the daily routine is governed by strict protocols developed over years of managing inmates assessed as highly dangerous. The Bureau of Prisons has stated that placement decisions are reviewed periodically and subject to internal oversight mechanisms. Still, the question persists among observers who see terrorism as fundamentally different from other federal crimes. But the distinction between crime and war is not always defined by the label of the offense, but by the legal process chosen to prosecute it. And that choice can shape not only the trial, but the rest of the inmate's life behind concrete and steel. What complicates matters further is that not all terrorism cases are handled the same way, even within the same historical period. The government has, at times, shifted strategies depending on the suspect's citizenship, location of capture, and nature of the alleged conduct. Those shifting strategies have produced a patchwork of outcomes, with some defendants tried in civilian courts and others in military commissions. As a result, two individuals accused of similar conduct could end up in entirely different detention systems. That inconsistency has fueled debate in Congress, in courtrooms, and across the public sphere. Yet once the gavel falls in a federal courtroom and a life sentence or decades-long term is imposed, the Bureau of Prisons becomes responsible. And within that system, only a limited number of facilities are equipped to house inmates assessed as posing extraordinary security risks. ADX Florence stands at the top of that hierarchy, reserved for cases deemed exceptional by federal classification standards. But the reasoning behind those standards and how they are applied to terrorism convicts in practice is where the story becomes more complex. Because placement is not automatic, and not every terrorism offender is sent there. The criteria involve layers of review, intelligence assessments, and institutional considerations that few outside the system ever see. And in some cases, the decision to send someone to ADX has sparked legal challenges and public scrutiny. The rationale behind those decisions reveals how the federal government balances punishment, security. Even within the Bureau of Prisons, terrorism alone does not automatically trigger transfer to the most restrictive facility in the country. Each inmate undergoes a classification review that weighs conduct, intelligence assessments, sentence length, and the perceived risk of influencing other prisoners. The Bureau uses a multi-level scoring system, but it also retains discretion to apply what it calls a greater security management variable. That variable allows officials to override standard scoring if they believe the inmate presents unique or extraordinary concerns. In terrorism cases, those concerns often center on communication, recruitment potential, or the symbolic influence of the offender's notoriety. Officials have testified in federal court that preventing the spread of extremist ideology inside prison walls is a central security objective. The concern is not simply violence, but organization and coordination within a controlled environment. Federal prisons house thousands of inmates serving long sentences, and group affiliation has historically created management challenges. In past decades, prison gangs have demonstrated how disciplined networks can operate even under restrictive housing conditions. Authorities argue that extremist-motivated offenders can present similar risks if allowed regular contact within general population settings. That possibility is one reason some terrorism convicts are placed in Special Administrative Measures, commonly referred to as SAMs. Special Administrative Measures are authorized by the Attorney General under federal regulation when there is a substantial risk of violence or communication that threatens national security. Under SAMs, an inmate's contact with the outside world can be tightly limited, including restrictions on mail, phone calls, and media interviews. The stated goal is to prevent coded messages or directives from being transmitted beyond prison walls. In high-profile terrorism cases, these measures have been applied for years at a time, subject to periodic review. Placement at ADX Florence often coincides with the imposition of SAMs, though the two are legally distinct decisions. ADX provides the physical infrastructure designed to enforce those communication controls with precision. Single occupancy cells, remote operated doors, and limited movement reduce opportunities for unauthorized interaction. Critics argue that such restrictions amount to prolonged isolation that raises serious constitutional and human rights concerns. Civil liberties organizations have filed lawsuits challenging both the conditions at ADX and the breadth of special administrative measures. Federal courts have generally upheld the government's authority to impose heightened restrictions when justified by documented security risks. Judges reviewing these cases often defer to the expertise of prison administrators in matters of institutional safety. Still, the litigation reveals how controversial these placements can become. One issue repeatedly raised in court is whether terrorism offenders are being treated differently based solely on the nature of their crimes. The Bureau of Prisons maintains that decisions are individualized and rooted in documented conduct, not political labels. Records show that not every terrorism convict is assigned to ADX. Many serve their sentences in high-security or even medium-security federal institutions across the country. Those placements reflect a determination that the inmate can be safely managed without administrative maximum conditions. But in cases where prosecutors have presented evidence of ongoing extremist ties or attempts to communicate coded messages, officials have chosen a different path. What followed in some of those cases shaped national debate about prison policy and constitutional limits. For example, several high-profile terrorism defendants convicted in civilian courts were initially placed in other facilities before being transferred to ADX. Those transfers often occurred after internal reviews citing security concerns that extended beyond routine incarceration. The public rarely sees the internal memoranda supporting those decisions, but court filings sometimes reveal fragments of the rationale. These documents reference intercepted correspondence, monitored communications, or intelligence assessments provided by federal agencies. The intersection between criminal justice and national security becomes particularly visible in those moments. It is also where the question of military detention resurfaces. Some lawmakers have argued that individuals convicted of acts linked to foreign terrorist organizations should be treated as enemy combatants. However, once a civilian court has exercised jurisdiction and imposed sentence, shifting custody to the military raises significant constitutional complications. The Supreme Court has consistently affirmed the primacy of civilian courts in adjudicating federal crimes committed within United States jurisdiction. Transferring a convicted civilian inmate into military custody after sentencing would likely trigger immediate legal challenges. That legal barrier reinforces the structural separation between military and civilian systems. The Bureau of Prisons, not the Department of Defense, is the agency legally equipped to carry out federal sentences. Another practical consideration involves long-term incarceration. Military facilities are not designed to house civilian convicts serving life sentences or multi-decade terms following criminal trials. They are structured for service members under court-martial or detainees held under specific wartime authorities. Federal prisons, by contrast, are built for permanent criminal confinement under statutory sentencing schemes. Terrorism convictions in civilian court frequently carry life imprisonment or terms measured in decades. The Bureau must therefore manage these inmates for the duration of their sentences, often for the rest of their lives. That long horizon influences placement decisions, especially when officials consider the potential for radicalization over time. Prison administrators have stated publicly that managing ideology within correctional settings requires sustained oversight. In their view, administrative maximum confinement is one tool used in particularly sensitive cases. Yet data released over the years shows that the total number of terrorism offenders in the federal system is relatively small compared to the overall population. Only a subset of that group is housed at ADX Florence. That fact complicates the narrative that all terrorism convicts are automatically sent to the nation's most restrictive prison. Instead, placement reflects a layered evaluation that blends criminal history, behavior, intelligence, and institutional capacity. Still, critics question how transparent that evaluation process truly is. Much of the supporting information is classified or shielded from public disclosure on national security grounds. As a result, outside observers often see only the outcome, not the internal calculus that produced it. That opacity fuels suspicion and debate. It also reinforces the perception that terrorism cases occupy a gray space between criminal justice and armed conflict. The federal government insists that civilian prosecution demonstrates confidence in constitutional institutions. Proponents argue that bringing terrorism suspects into federal court affirms the rule of law rather than suspending it. What remains unspoken in most public debates is what life actually looks like after the transfer order is signed and the bus doors close. By the time a terrorism convict arrives at ADX Florence, the legal arguments have largely ended, but the administrative reality is just beginning. Intake at administrative maximum is deliberate and procedural, involving layered reviews that determine housing, restrictions, and monitoring requirements. The inmate is assigned to a single cell designed for separation rather than congregation, built from reinforced concrete and steel. Movement is tightly scheduled, often limited to brief, controlled periods outside the cell under direct supervision. Contact with other inmates is minimal, sometimes non-existent, depending on the specific management plan in place. Communication privileges, when allowed, are structured through monitoring systems intended to prevent unauthorized messaging. Officials describe this approach as preventative rather than punitive, emphasizing institutional safety over symbolic severity. Yet the distinction between prevention and punishment is often debated outside prison walls. Former prosecutors have argued that housing terrorism convicts in federal facilities demonstrates confidence in domestic institutions. They contend that the criminal justice system is strong enough to handle even the most serious national security cases. Others maintain that the extraordinary conditions imposed at ADX reveal an implicit acknowledgement of ongoing risk. The Bureau of Prisons conducts periodic reviews to determine whether continued placement at administrative maximum remains justified. Those reviews consider behavior, compliance with institutional rules, and any new intelligence assessments. In theory, placement is not necessarily permanent, though in practice many inmates remain for extended periods. That reality has prompted questions about long-term psychological effects associated with restrictive confinement. Courts examining those claims have required evidence that conditions exceed constitutional thresholds of cruel and unusual punishment. In most cases, judges have concluded that the government's security rationale outweighs the asserted harms. But each ruling reinforces how central risk assessment has become in terrorism incarceration decisions. The federal system does not publicly disclose detailed criteria for every transfer, citing security sensitivities. As a result, the reasoning behind certain placements remains partially obscured from public view. That opacity contributes to continuing suspicion that terrorism cases receive exceptional treatment. Yet federal officials insist the framework applied to these inmates exists within established statutory authority. They argue that terrorism is prosecuted as crime precisely to avoid indefinite military detention without trial. In that sense, placement in a federal prison is presented as evidence of procedural normalcy. Still, administrative maximum confinement represents the far edge of that normal system. The facility's architecture itself communicates containment, with remote-operated doors and narrow sightlines. Every design element serves the goal of control and predictability. For prison administrators, predictability reduces the possibility of coordinated disruption. For critics, the same predictability can appear indistinguishable from prolonged isolation. The broader policy question extends beyond one facility in Colorado. It touches on how the United States defines the boundary between criminal accountability and national security. When suspects are captured domestically and prosecuted in federal court, the system follows familiar procedural tracks. But the crimes themselves often involve international networks and ideological motivations tied to global conflicts. That dual character complicates classification decisions after conviction. The Bureau must balance the individual's legal status as a convicted criminal with assessments of broader security risk. Those assessments can involve intelligence information not typically associated with ordinary criminal cases. The integration of intelligence considerations into prison management is one of the least visible aspects of the process. It is also one of the most controversial. Civil liberties advocates warn that reliance on classified information limits meaningful external oversight. Government officials respond that certain details cannot be disclosed without compromising ongoing investigations. That tension reflects a larger national debate about transparency in security matters. Meanwhile, the inmates' daily routine continues under established institutional rules. Meals are delivered through secure slots, recreation occurs in controlled enclosures, and medical care follows standard bureau procedures. For some terrorism convicts, these routines persist for years without significant modification. For others, behavior and compliance can result in gradual adjustments within the confines of administrative maximum policy. The possibility of change exists, but it is neither automatic nor guaranteed. Public attention often resurfaces only when legal challenges are filed or high-profile anniversaries approach. At those moments, the original question reappears. Why federal prison rather than military custody? The answer, in practice, reflects a series of deliberate legal and administrative choices made long before incarceration begins. Civilian prosecution leads to federal sentencing. Federal sentencing leads to Bureau of Prisons custody. Within that custody, classification determines the specific facility. And in cases where risk assessments exceed the capacity of ordinary high-security institutions, ADX Florence becomes the endpoint. That chain of decisions is procedural, not rhetorical. It rests on statutes, regulations, and institutional discretion. Whether that structure strikes the correct balance between liberty and security remains a matter of continuing debate. What is clear is that the destination is not arbitrary. It is the product of jurisdictional boundaries and risk management judgments embedded within federal law. In the end, certain terrorism convicts are sent there instead of military facilities because they were prosecuted as criminals, not detained as combatants. That choice carries consequences measured not only in years of confinement, but in how a nation defines justice in the face of violence. If this story kept you watching, the next one will stay with you even longer. Subscribe for more real prison documentaries.